10, 9, 8, 7, 6, 5, 4, 3, 2, 1, 0.
Hello, my friends. And thank you so much for coming to spend part of your Tuesday, March 12th, 2024 with me. I know you have a lot of choices of where to spend your time, and I am truly honored that you choose to spend some of your time with me. How is everybody? How is everybody in Boston today? How is everybody in Norfolk County today? Are you guys hot? Because there was fire today in Dedham. There was fire at Norfolk Superior Court. And I know it's late, you guys, and I apologize for the late hour, but this is the only thing that could fit into my schedule today. And after I watched this hearing this morning live, there was no way I couldn't cover it today. There was no way. And so many of you asked me to cover it, and so many of you are waiting. And I thank you, because it is 10 p.m. on the East Coast. And I know that most of you are East Coasters. And I'm really sorry to my viewers in Scotland and Europe, because it is 6 hours ahead there, 6 or 5. I don't know if you guys do daylight savings. And if you're in Australia, it's already tomorrow. So I think you guys are good. And my West Coasters, it's only 7 p.m. So, hey, it's good. You could feel the heat. You could feel the heat from there. Yeah, it was, and as I was going through this and prepping the show, and I like to prep the show, and I like to have an outline, and I like to have clips of things that I want to show to you. And as I was trying to get to all of the important parts of the hearing, there are just so many important parts of the hearing. Today was like a master class in lawyering from the defense. It really was. And smooth as butter, Alan Jackson was, per usual, very, very, very excellent trial lawyer. And Yannetti got a chance to shine today as well. He's also an excellent lawyer. He made some great points. He had a lot of passion, you could tell, for what he was talking about. And he even said at one point that he did not even want to bring this motion, that it pained him. He said, it pains me to have to make this motion to disqualify the DA's office, because I have worked with some of the best. And he just couldn't believe how egregious, in his opinion, the conduct of Michael Morrissey was in this case. And in his opinion, it's one of the reasons why Michael Morrissey's office should be disqualified. The indictments should be dismissed. And poor Lally. I'm just gonna say it. He was racing through his arguments. Racing. I can't even put him on 1 1/4 speed, because that's how fast he was talking. And there was a lot of heavy sighs going on, a lot of kind of like, oh my God, I know I have to get up here and argue this, but I really, I'm going to do the best I can, but I really do not have a good argument here. And there were some bombshells. And I don't want to, and I asked you guys in the chat, because you guys have been chatting in the chat all day. I said, please, no spoilers, because some people perhaps did not watch the entire hearing. And I thought, should I, free Billy Tibbetts, free Billy Tibbetts, and Lady Benson, free Billy Tibbetts. Hey, Australia. This is an international story, truly. It truly is. Some people thought this was just going to be a national story. Initially, it was just a Boston story. It was just a Norfolk County story. And it is now international. And I know you guys are watching it, and I know you're out there, and I know you're riveted, just like we are, because Karen Read could be any one of us. Any one of us. And after what we learned today, how can this case even go to trial? I mean, there's so much reasonable doubt here. We heard some talk about, I'm not going to spoil it for you, because there are some certain parts I want to watch. In fact, we may just watch the whole hearing. It's only an hour and 10 minutes. Oh, Stephanie's already watched it 5 times. Okay, so you did get to watch it. there's some information about the Google search that Jen McCabe made, information about the formal introductions and why those formal introductions were not necessary. There's some information about integrity and why integrity is a question here for Michael Morrissey and his office. There is some personally vindictive information for me, or information that I feel has personally vindicated me in certain ways. And I'm going to get to that because I'm going to show you some clips and then I'm going to show you what we found out in court today. And I can say, I was right. I was right. There's some information about a highly irregular conference call that happened that you're going to find out about. There's going to be some information that you are going to find out that the DA gave permission to certain people to dispose of their cell phones, which was highly improper, to put it mildly. You're going to find out about a phone call that happened 5 minutes before 2:27 a.m. by two of the players in this case. And you are going to hear Lally try and pull focus from the main issues and throw the distraction onto Aidan Carney and Karen Reed's communications. And it's just a whole bunch of like, look over here. So, how many of you have watched the whole entire hearing? Let's just start it, and if we have to, we'll fast forward it a little bit. But there's so much good stuff here, and it's only an hour. But I'm going to stop it, and I'm going to give you my thoughts on it as it goes on. So, if you haven't seen it, buckle up. If you have seen it, you're now going to see it with me because we're going to watch it together, and I'm going to tell you what I think as we stop it as we go along. Now, remember, if you have not watched my streams before, I've done a lot of deep dives into this case. I don't even know how many are on my playlist already, but there are a couple that I've done with regard to, if I just put somebody in timeout, I'm really sorry because I did not mean to do that. It just, I touched something. Sorry. I've done a lot of deep dives into the motions. I've done deep dives into the motions that we can actually get our hands on because some of them are still sealed or impounded, as they say in Massachusetts. But if you have not watched those, you should go back later and watch them so you can get, I'm not going to do a whole huge deep dive into those motions and what we've already discussed. So I've already done 12 videos on this case. Most of them are 3 hours long. So there's a lot of information. There's a lot of information out there, but I know that you guys who are watching are very familiar with this case. So the last stream that I did was the motions hearing of January 5th of 2024. And you may recall, I think, if this is in order. No, I think it was the exculpatory evidence one. In any event, you may recall that at the last hearing, Judge Cannoni said, we are going to come back on March 12th. Originally, this was supposed to be the trial date, as you know. And she said, and we've got all day. We've got all day to hear these motions. We're going to do the motion to dismiss, and we're going to do the motion for sanctions and for disqualification. And we've got all day. So it was a bit of a surprise today when she said you each have 10 minutes to argue your motion. So there's that. Let's just give this a go. I know you've watched it, but we're going to watch it together, and we're going to talk about it.
When we were last here on February 26th, I first anticipated that today would be for all motions, but I did read the very detailed affidavit from defense counsel regarding dates and what we should cover. And so today, as you know, I changed some of the dates to accommodate you.
I've changed some of the dates to accommodate you right off the bat. She's like, I've been accommodating you. I've been very, very accommodating. And notice today her tone and her demeanor has changed quite a bit. Her tone and her demeanor is much more friendly. She's much more trying to get along because she knows that she is under a microscope. She's under a microscope. And she's going to tell them several times, I've read all your papers. I've read all your papers. I've read all your papers. It's all in the papers. I know. I've read it. I've read it. I've read it. You don't have to argue it again in front of me because there's a lot of stuff that she does not want said in open court. And you can just tell. either she's protecting herself or she's protecting other people, but there's a lot of stuff that she did not want the TV viewing audience and the YouTube audience to hear today. And she cut them off, and you're going to hear it. So listen, yeah, she was more friendly, but she still interrupted the defense a lot.
Accommodate, I think there was some short trial dates you may have had, or restitution dates. And so you did get the order on the new dates. So today is only for filing all Rule 17 motions and for the motion to dismiss under Odell and the motion for sanctions. So I don't remember if it was Mr. Jackson or Mr. Yannetti who last time said that I was operating from a blind spot because I didn't have the information that was disclosed to you folks from the U.S. Attorney's Office.
That wasn't meant to be an insult, and she knows that. It was like she's operating from a blind spot because she doesn't know what they know. She did not have, she did not look at all of the stuff that the feds turned over. Yes, Mark, her voice is nervous. You can hear her voice shaking. You can hear it shaking.
So you were good enough to get me the entire packet, which I appreciate. I read it. I see now how the federal investigation began and when it began. I've also read the pleading. So the motion to dismiss, defendant's motion to dismiss is around 50 pages with attachments. The supplement is about 15 pages. The Commonwealth's opposition is about the same. The motion for sanctions is about 30 pages. There's no supplement, Mr. Yannetti?
There's no supplement.
Okay, and then the Commonwealth had about 25 pages, and then the Commonwealth supplement covered both motions, and the Commonwealth had originally probably hundreds of pages of exhibits. So I have read all of that, and I am mindful also, I keep coming back.
Okay, if anybody knows, somebody said, can you point out John's parents? I'm just going to, is this John's mom right here? Does anybody know the lady in the gray sweater with the black stripe across it? I mean, I think I've seen her outside the courthouse. Does anybody know? Who knows? I think that's her. Yes. Thank you, Brian. Hi, Brian. Brian, I'm going to talk a little bit about the stream that you did last night, where I think I got some shade from one of our other people that I've been on Court TV yet with. So interesting. Okay, so this is John's mom. And then can you guys tell me who, because you guys are far more knowledgeable than I am. My understanding is that the McCabe's and the Alberts were not in court today. Is that true? Who are these two, the blonde women? Is this Karen's family here in the front row? I think that's the front row. Yeah, that's the row right behind Karen. Jen McCabe had everyone over all to her house for this. Okay, yes. Okay, that's John's brother. Okay. Oh, that's John's brother where? Jen was missing for a reason. Okay, so this is Karen's family in the front. Yeah. You guys will tell each other. Karen's family. Okay. All right, good. Like to see. Okay. All right, here we go.
I've also read the pleading. So the motion to dismiss, defendant's motion to dismiss is around 50 pages with attachments. The supplement is about 15 pages. The Commonwealth's opposition is about the same. The motion for sanctions is about 30 pages. There's no supplement, Mr. Yannetti?
There's no supplement.
Okay, and then the Commonwealth had about 25 pages, and then the Commonwealth supplement covered both motions, and the Commonwealth had originally probably hundreds of pages of exhibits. So I have read all of that, and I am mindful also.
She's out of breath.
I keep coming back to the letter that was written to me on February 26th from the Deputy U.S. Attorney, who says, "We expect, of course, that the parties will disclose orally the materials in court only as necessary to further the proceedings." So I've
Okay, so she's now being very mindful all of a sudden of what's allowed to be said in court, and she's taking the admonition, warning, and or guidance of the AUSA very seriously right now. She doesn't want to overstep. Somebody said, why is she counting pages? Because she's trying to say, this is why I'm only giving you 10 minutes, because this is why because it's already so many pages and I've read it all and I've digested it all and I know the case. And so just try and give me your most salient points so that I can get out of here, turn the cameras off, and we can all be done with this. Yeah, I don't know who said that. Who can I give credit? I mean, like, oh, Magnolia Gypsy. I mean, like, why is she counting papers? That's why. That's exactly why. Because she wants everyone to know that she read it.
Read everything. I'm going to give each side 10 minutes, and we're going to start with.
Everyone heard that and they're like, what? Like, I flew from LA for 10 minutes. You told me that we were going to have all day. And this is a very important, it's two motions. Very important, very serious, very egregious. 10 minutes? Okay. But then she does give him an extra 5. So I guess that was kind of nice. Lally could have used 5. Lally did not need any time at all because he raced through everything he had to say and he wanted to get out of there too. So it's kind of like, Yannetti and Jackson had all day to spend there and they would have happily spent all day there. And she wanted to leave and Lally wanted to leave. And so this thing was done in an hour and 10. And that might even be stretching it. There might even be some, like a little bit of couple of minutes of footage at the end of this. But buckle up, buttercups.
Motion to dismiss. So, Mr. Jackson, I'll hear you. I think it would be particularly helpful if you were to focus on the exact prejudice to the defendant and how this all goes to the core of the Odell motion. And as you know, that's an awfully high bar. So go ahead.
As you know, that's an awfully high bar. In other words, I'm probably not going to grant your motion. So I'm going to put it out there for everyone in TV land to understand that this is a very high bar. And I've said all along that it's a high bar. And I've said all along that these motions are rarely granted. What I'm going to tell you today is that after hearing these arguments and after hearing what was turned over from the feds, my opinion may be shifting a bit. So yes, it's a very high bar. In my opinion, I'll tell you my opinion at the end. Don't forget to ask me.
Your Honor, I will try to edit my comments to stay within the 10-minute mark. It's very difficult to do that. I did not know that we were going to be under such incredible time constraints. As a matter of fact, I thought that the court said the last time we were in court, we had basically your words.
Yeah, all day. But that was when we had all the motions, but it's just these two motions
right,
today.
But they're big.
They're big.
Consistent with.
Why don't you go ahead and start? If you need additional time, tell me. But it would be important to.
He's like, I rehearsed for 3 days for this. I cannot get this down to a tight 10. There's no way I can get this into a tight 10 right now. It's like, I had like 90 minutes prepared, Your Honor. If you're a comedian, you know what a tight 10 is, right, Obi?
Focus your argument. Again, I'm mindful of what the U.S. attorney said to me in that letter.
And I am as well. And that mindfulness suggests that my comments will be directed to that which is necessary to further the proceedings.
Okay.
Which means that
right ahead.
I'll start with the basic rule of Odell. We start with the postulate that any distortion of the evidence, that's where we start. Any distortion of the evidence during the course of a grand jury proceeding impairs the integrity of the indictment, if there is an indictment, and pursuant to Odell, that requires dismissal. In this particular case, there were myriad examples, which I will, again, I'll edit. I was going to go through several, but I'll just touch on them very quickly.
Your memo, I have to say, your memo is very thorough and very helpful to me because you outline everything and same in your supplement.
Thank you. The first point I want to discuss is what we believe is the failure to disclose Sergeant Michael Lank's personal lifelong relationship with some of the individuals, specifically the individual Chris Albert. There was a comment or an incident, I should say, that we referred to in our moving papers that dealt with Chris Albert and Sergeant Lank years ago. They have a long-standing, years-long relationship. And I'll close this loop in just a second, but if you'll allow me, that relationship goes all the way back to 2002 at least. And there was an incident in which Sergeant Lank and Chris Albert had gotten into what can easily be described as a bar fight. Chris Albert had gotten into a bar fight of some sort. Michael Lank walks out of the same bar or an adjacent bar. He had been drinking with his buddy Chris. He walks out, stumbles out, announces to the participants in this fight that he was, quote unquote, deputizing himself and ultimately came to Chris Albert's aid. That was with the specific intent to assist an Albert in getting out of a legal jam all the way back to 2002. The reason I bring that up, and by the way, both of the individuals involved, not Sergeant Lank, both of the other individuals involved were ultimately arrested by Sergeant Lank. That case went to trial, and both of the individuals were found not guilty of assault. And that's after Michael Lank engaged in fisticuffs with at least one of the men, to the degree that the Canton police officers had to pull him off of the individual.
So this is in your memo, and it also is exhibits C through E
That's right.
attached to your memo.
And the reason this comes to a head, and the conflict of interest comes to a head, is because Michael Lank ultimately was the first person to walk into Brian Albert's house. During the course of the grand jury.
Yep. Michael Lank was the first person to walk into Brian Albert's house the morning that Officer John O'Keefe's body was found on his front lawn on January 29th, 2022, because he was looking for a friendly, is what he's going to tell you. He was looking for a friendly.
Nobody elicited information from Michael Lank that he had a close personal relationship with the Alberts, that he had in years past come to the Alberts' aid. And yet he was the first person that came into the house. Even the grand jurors were stunned by this and asked, the specific grand jurors asked Michael Lank and asked the Commonwealth, or through the Commonwealth of the witness, why didn't Brian Albert ever even come out of the house? And I think we have the answer. And the answer is because the Albert, specifically Brian Albert, was waiting on a friendly. And they got that friendly through Michael Lank. That was withheld from the grand jury. Sergeant Lank is a longtime childhood friend of the Alberts. The Canton Police Department was conflicted off the case because of those personal and familial relations.
He was waiting on a friendly face to come into the house so that he knew what he had to do. All right, a friendly. That was great. The golden handshake. If you watch the stream that I did on the Massachusetts State Police officers that were trading favors like driveways, or they were trading commercial driver's licenses for driveways and Voss water. And this is very interesting because Karen Reed is drinking a Voss water. Pretty sure that's Voss on the table in front of her. That was the water that MSP was trading commercial driver's licenses for. Driveways, plunge pools, the golden handshake. Very reminiscent of that scheme. A lot of things in this hearing reminded me of that.
Relationships that the Alberts have with Canton Police Department. And Sergeant Lank has a history of using his position as a police officer to shield the Alberts from criminal liability. That was never brought out. That's the kind of distortion that Odell talks about.
Distortion brings me back to Ruby Franke and Jody Hildebrandt. I mean, truth and distortion. So this is the first prong of his argument, that the grand jury was not made aware of the close relationships between Lank and Proctor with members of the family where Officer John O'Keefe's body was found, and other players in the case, other witnesses in the case. The grand jury was not made aware of how close those relationships are, and therefore it wasn't fair. That's what he's going to say. It wasn't fair. Tell me what you think of that argument after we hear the end of this argument.
Another broad example or a broad category that I want to discuss briefly deals with Trooper Michael Proctor. The Commonwealth withheld from the grand jury clear and even more egregious conflicts of interest as they pertain to Michael Proctor. Sergeant Lank was aware of this irremediable conflict that Canton Police Department had and that he should have had with the Alberts. So what does he do? He calls in Massachusetts State Police. And who do they send but Michael Proctor? And that's like jumping from the frying pan into the fire.
Jumping from the frying pan into the fire. My understanding is that Massachusetts State Police would come in regardless if there was a fatality, right, in motor vehicle accident, under Massachusetts state law, that Mass State Police works in conjunction with Norfolk DA's office. However, we went over this on another stream too. They came in and they were called in before John O'Keefe was even pronounced Correct me if I'm wrong.
That's the same Michael Proctor who's also years-long close family friends with the Alberts. The Proctors have called the Alberts their, quote, second family. And to that point, now we have benefit of some hindsight, and that's the federal investigation. We have been saying since September 16th, 2022, in lengthy motions that we filed before this court and filed with the Commonwealth, there is a conflict. You're not investigating the conflict. That conflict was never described to the grand jurors. And we've been rebuffed at every single turn. Newly uncovered text messages, but from the feds, revealed that on January 19th, 2022, think about that date, that's 10 days before the incident. January 19th, 2022, Michael Proctor texted his own family members discussing the specifics of having Julie Albert babysit for his toddler child. We should all let that sink in for a second.
Yeah. So Proctor is not close to the Alberts at all, and yet they discovered text messages on his phone that he was going to have Julie Albert babysit his toddler, and Lally's going to come in and say, but she never did babysit for his toddler, so it doesn't really matter. Well, do you not really know a person that you're going to ask to babysit your toddler? Does anybody watch the show? There's a show on, I don't even know what channel. I think it's Stars, called Hightown. And it's about the Massachusetts State Police on Cape Cod and the corruption that goes on there. And there was just an episode recently where some girl hired somebody she didn't even know to babysit her toddler, and horrible things happened. So you cannot tell me that this guy's not close to this family when he's trying to find out if Julie Albert will babysit his toddler. I mean, you know.
So yeah, I understand that.
There is a level of closeness that cannot be overstated. Michael Proctor is so connected to the Alberts that he was entrusting them, or willing to entrust the Alberts, to be caregivers for his toddler child. And it's not lost on anybody in this courtroom that for 2 years, the Commonwealth has been denying it and still denies it in their opposition paperwork. They still say, well, there's nothing to see here. It's Michael Proctor's sister who really is friends with Julie Albert, and that's not a big deal. Everybody looked the other way. As a matter of fact, Ms. McLaughlin wrote the following in her opposition. Trooper Proctor's supposed close and personal relationship with the Alberts is, quote, entirely unfounded and a desperate creation of the defense, a desperate creation of ours. She says we created this. But now we have the benefit of the federal investigation. And the Commonwealth finds itself in that very unenviable position of having to eat some very distasteful words, because we didn't create anything. And there's more. On February 1st, 2022, 3 days after John O'Keefe was killed, there was another text message. In this one, Michael Proctor's sister texts Michael Proctor very specifically and writes the following, quote, just saw Julie, and Julie said when all this is over, she wants to give you, Michael Proctor, a thank you gift.
Okay. Okay. 3 days post Officer John O'Keefe's body being found on the front lawn of Brian and Nicole Albert, Julie Albert is telling Proctor's wife that when this is all over, she wants to get him a gift. Let's just rewind that, because that is so important. Why else would you get someone a gift unless they were doing you a favor?
3 days after John O'Keefe was killed, there was another text message. In this one, Michael Proctor's sister texts Michael Proctor very specifically.
Okay, sorry. Michael Proctor's sister texted Michael Proctor and said,
and writes the following, quote, just saw Julie, and Julie said when all this is over, she wants to give you, Michael Proctor, a thank you gift.
a thank you gift. What is she thanking him for? The gift is jail. Julie Albert's son is Colin Albert. Colin Albert is the one who they went to great lengths to tell you was not in the house that night. He was also pulled over in a Ford Edge on campus sometime later. He was also served with a federal subpoena to testify in front of the federal grand jury. I don't know. I'm not accusing him of anything, but why else would Julie Albert tell Proctor's sister to tell Proctor that she wants to get him a thank you gift?
Michael Proctor didn't respond with, that's inappropriate. These are witnesses. These are potential suspects. Please tell her, don't ever do that again. Don't ever suggest an exchange of gifts again. That would be inappropriate. I'm going to go write a report. I'm going to turn it over to Mr. Lally, and Mr. Lally's going to turn that information over to the defense and to the court. No, that's what he should have done.
Yeah, but maybe he should have asked for a plunge pool. Are you kidding me right now? This is so explosive. So explosive, you guys. Oh, and this is just the first one. Like it gets worse or better depending on which way you're looking at this case. But the mountain of reasonable doubt that is piling up on the side of the defense in this case is mind-boggling. And you can see just from the opening 10 minutes, probably the judge spoke for 5. So the opening 5 minutes of Alan Jackson's opening monologue, I want to say, but it's his argument. He has already explained to you why none of those people came to court today. And they've been at every single court appearance, right? You guys are there. I'm not there. And listen, I've got no dog in this fight. Okay. I've got no dog in this fight. And that is an intentional pun. I don't know any of the players here. I don't know Karen Reed. I don't know her attorneys. I don't know anybody from the prosecution. I don't know anybody sitting in that courtroom right now. I don't know any of the other YouTubers that are covering this aside from Brian from LTL2 Crime. Shout out to Brian because we've worked together before on not just this, but other cases too. And Sean McDonough, who came on my show once. And that's how we met, talking about this show. We didn't know each other before. I don't know anybody. So this is coming from somebody who's just looking at this from the outside with 30 years of trial experience, trying to figure out how in the hell this got so far.
What he did do is he responded, get Elizabeth one, his wife. In other words, get the gift from my wife. It'll be a little less obvious. So now we have the lead investigator from Massachusetts State Police literally discussing the exchange of gifts between the Albert family on the one hand and the Proctor family on the other hand as a thank you, their words, for helping the Alberts out of a jam. And if you looked up quid pro quo in the dictionary, you would find this set of text messages. 2 years later, to the day, on February 1st, 2024. Now let's fast forward 2 years later.
Let's fast forward to a few years later. Anybody know that song? I think there's a little Alanis Morissette in there. You guys know, I think in song lyrics, we'll fast forward to a few years later. And here's what Proctor's going to say before he goes to testify in front of the federal grand jury.
Michael Proctor finds himself on the witness stand in front of a federal grand jury, which we just found out about. That grand jury was tasked with a singular commission, and that was investigating crimes of public corruption by law enforcement in relation to this case. And during that testimony, he was confronted with these and myriad other examples of evidence of his close ties to the Albert family. And he admitted to an AUSA under very intense questioning that not only does he know the Alberts, and does he socialize with them, does he drink with them, does he go to pool parties with them, but he told his partner, Yuri Buchnick, all of this before Yuri Buchnick testified at the grand jury and before he and Buchnick actually interviewed Chris Albert.
So now Buchanan's in on it too, because he knew about the close relationship between Proctor and Chris Albert before they even went to interview Chris Albert. And this is why they said, after formal introductions in that witness statement that we read together, and I thought that was so weird when I read that, and we talked about how weird that was. And now we're going to see why. It's confirming the things that we thought, and it feels like a little bit of validation.
Why does that mean something? Why does that mean something to the court and to this argument? Because when Yuri Buchnick testified before the state court grand jury, he testified that, quote, following formal introductions, end quote, Julie Albert and Chris Albert provided their phone numbers. Following formal introductions. That was a clear deceit on the grand jurors. Yuri Buchnick knew, as did Michael Proctor, they didn't need formal introductions. Michael Proctor was considering having Julie Albert babysit his kid 10 days ago. Actually, at that time, 13 days ago. That left the grand jury with the intentional false impression that these people literally do not know each other. They've never been in contact. They're complete strangers. That was a lie. That was a concerted effort to hide that relationship and to hide the conflict of interest. And the grand jurors were fooled. They were left with the impression, Michael Proctor, Yuri Buchnick, they don't know these folks. They're completely neutral, independent investigators, and nothing could be further from the truth. And the revelation of this evidence culminated in front of that same grand jury on February 1st, 2024. Under additional intense questioning by the assistant United States attorney, Proctor was caught in his own web of deceit and testified as follows, quote, this is the AUSA talking, or asking the question. So obviously we're asking questions about your relationship with Julie Albert, with Chris Albert, and with Colin Albert.
Oh, so what? So when the AUSA is questioning him, I think he may tighten up his game a little bit. Let's hear what he says. This is Proctor testifying in front of the federal grand jury.
Do you understand that? Answer, yes, sir. Question, and you're saying that you're minimizing, quote, minimizing your relationship to the grand jury, correct? Answer, yes. He finally, under the scrutiny of a federal grand jury, admitted that he had been lying about his relationship to the Alberts, which means he lied to the grand jury, which means the evidence was distorted in front of the grand jury. And that is the burden that Odell requires.
All right, so
distortion, my friends, truth and distortion. What say you? I know you're going to tell me what say you, but he admitted that he was minimizing the extent of his relationships with some of the players in this case. And that, my friends, is the big problem.
your time is up, which includes me interjecting. Do you want 5 more minutes?
If I could
Yeah.
implore the court.
I'd like you to sort of get to the questions I asked as well. All right. I know you're reciting the evidence that I've read, but so I'll give you 5 more minutes. Go ahead.
Thank you.
I know you're reciting the evidence that I read. He's been preparing for this for a long time. He's been preparing for this for, I don't know, 2 weeks since the last hearing when she said that's when we're going to have all day to argue these motions. And now you can have 5 more minutes and please say what I want you to say. Okay.
I want to shift gears to another example or another series of examples of evidence that was distorted before the grand jury. And that deals with the use of, or the insinuation of Kevin Albert, yet another Albert, at the behest of Michael Proctor. Kevin Albert is a sworn Canton police officer. On day 1, the Canton Police Department was completely recused off the case, in no small part because of Kevin Albert.
Kevin Albert is Brian Albert's brother. Brian Albert is the homeowner where Officer John O'Keefe's body was found on the lawn. Brian Albert is a Boston police officer, was at the time. And his brother, Kevin Albert, is a Canton police officer, or was at the time. I don't know if everybody has retired to save their pensions, but you guys know better than me. But I don't have a family tree drawn up. I was going to try and do that today, tell you who all the players were, but the day got away.
The fact that John O'Keefe's body was found on Kevin Albert's brother's lawn. Yet the evidence that has been disclosed by the federal investigation, which we were not privy to, is that Michael Proctor actually utilized Kevin Albert's services to coordinate with the very witnesses who should have been potentially suspects and certainly should not have been subject to coordination by an Albert, when that's the very person on whose lawn John O'Keefe, or his brother's lawn, John O'Keefe was found. I want to turn to
Kevin Albert is still on Canton PD. Okay. Okay.
at least one more situation
Okay.
In my remaining minute or so, given the fact that this is curtailed. And this is not in our papers, but obviously it's a complete and probably the most obvious distortion of the facts. The Commonwealth suppressed one of the most obvious pieces of exculpatory evidence in the entire case, and that was a piece of evidence that they know torpedoes their entire case and their theory of this case, and that's Jennifer McCabe's Google search at 2:27 a.m., how long to die in cold.
I'm just going to pause this for a minute because I want everyone to pay close attention to this. Because the truth shall set you free. And justice tastes pretty sweet. Okay, here we go, everyone. Here it is.
They had her phone at the time of the grand jury. They had her complete extraction of that phone at the time of the grand jury. They had a Celebrite report, Your Honor, at the time of the grand jury, and yet they did not present this evidence. They claim, oh, well, we didn't have the right version of the Celebrite software. That's on them. That's not our fault. Certainly not Ms. Reed's fault. That's their fault. Get the right software. If you're going to bring this case, do it the right way. They say their argument is, well, we just didn't have the right software, so we didn't have the information. That's not true. They did have the information. It was sitting in her phone. They just didn't do their job in extracting. And should the Commonwealth once again stand up in some sort of desperate pitch to dispute that time and this critical evidence, the court should note the following. Not only does the Celebrite report confirm the search and the time of that search, not only do our experts confirm the search and the time of that search, but now a Quantico-trained special agent with the FBI's Regional Computer Forensic Lab, in other words, the United States Federal Bureau of Investigation, also specifically confirms that that search was made on Jennifer McCabe's phone, and it was made on or before 2:27 a.m. on January 29th, 2022. That fact, Your Honor, is—
How do you overcome that? How do you overcome that? A Quantico trained FBI agent analyzed the data and the phone and it unequivocally comes to the conclusion that Jennifer McCabe's phone Googled how long to die in cold at 2:27 a.m. on January 29th of 2022. This is an independent third-party FBI specialist who does not work for the defense, but who is investigating the investigation. And that, I don't even think we need to go any further, but we're going to go further because there's more. I don't know how you overcome this. Because yeah, she did do the 2:27 search for how long to die in cold. And then she did do 2 more searches after 6 a.m. The best is yet to come. I know. It's great. No spoilers, you guys. No spoilers.
is no longer open for debate.
No longer open for debate.
And none of that was presented before the grand jury. I'll conclude by saying any one of these examples, and I didn't touch on all of them, but any one of these examples, the gift giving, the babysitting, the telephone extraction, the Google search at 2:27 in the morning, all of these, any one of these would be enough to dismiss the charges as they sit here today. But the cumulative effect of this deception and all of it, this distortion from the grand jury, is too much for the court to ignore. The simple fact, Your Honor, is the presentation before by the Commonwealth before the grand jury in the state court action, it just wasn't fair. That's the easiest way to say it. It just didn't give Ms. Reed a fair shot. It just didn't. That presentation was packed with lies, known lies by the investigators, and the omissions and the manipulations and deceit by the very people that are supposed to be the ones that we in the community can trust.
That's right. We in the community are supposed to be able to trust them, and this is who is deceiving us. People in the chat, and I see a lot of you in the chat from Canton, the surrounding areas, have said, I knew that Canton Police Department, or I had heard that, you know, the local police departments around, in and around Canton have been corrupt, you know, my whole life, and now I'm finally seeing it. I don't know whether or not that's true, but when you hear stuff like this, it makes you go,
The ones that are supposed to protect our interests, and the law does not allow this sort of conduct to go unchecked. When the remedy, when this sort of travesty of justice occurs, is established by this state's Supreme Judicial Court, and that is dismissal of the indictment in its entirety. And it is not enough, and I'll be surprised if I don't hear it today, but something suggests, based on the moving papers that we just got from Ms. McLaughlin and Mr. Lally, are, well, Your Honor, we didn't know. We didn't know about the text messages. We didn't know about Proctor. We didn't know about Lank. All that stuff was revealed through the federal grand jury. It doesn't matter that Ms. McLaughlin individually didn't know, or Mr. Lally can say, I claim ignorance. I didn't know either. It's enough that an arm of their institution, law enforcement, they knew. And that was their job to tell the truth. That was their job not to fool or distort the Commonwealth. I'm sorry, the grand jurors. With that, Your Honor, thank you for the time, and I'll submit.
All right. Thank you.
all right,
Mr. Lally, we're going to.
all right, thank you. All right, you can see she's trying real hard to keep it together and to be nice, because we've seen her behave very differently in court. And the cat's out of the bag.
Start with 10 minutes. If you need more, you need to tell me.
He's like, yeah, no, I'm good.
And thank you, Your Honor. No, I think 10 minutes should be fine. I know the court has taken painstaking detail to go through all the material that's submitted, so I'll be as brief as I can.
Yeah, you might as well try and compliment her, because you don't have much else to persuade her with. So let's go.
Essentially, the defendant, as the court is aware, doesn't challenge the grand jury presentation under McCarthy grounds or probable cause standard. Defendant motions challenges under Odell. Odell essentially states dismissal of an indictment on impairment of the grand jury proceedings requires proof of three elements, as the court is well aware. One, that the Commonwealth knowingly or recklessly presented false or deceptive evidence to the grand jury. Secondly, that the evidence was presented for the purpose of obtaining an indictment. And three, that the evidence probably influenced the grand jury's decision to indict.
Okay. And if that's the standard under Odell that we're arguing, I'll argue it for you right now. Number one, that the Commonwealth knowingly and recklessly submitted false, deceptive evidence to the grand jury. Well, yeah, they did. They did when they had Proctor get up there and swear to tell the truth, and they did when they had Lank get up there and swear to tell the truth, and they claimed that they had no personal relationship with any of these people. That the evidence was presented for the purpose of obtaining an indictment. Well, yeah, that's why you have a grand jury. That is the purpose of a grand jury. Obviously, that's what the evidence was presented for, and that the evidence probably influenced the grand jury to indict. Well, yeah. These are troopers from Massachusetts State Police and police officers from Canton PD. Of course, we're going to believe them because they are the law. Of course, that's going to influence the grand jury to indict when a number of officers get up there and swear to tell the truth and they don't tell the truth. So there you go. There's your motion. Let's hear how he tries to get out of that.
None of which I would submit the defendant has met their burden with reference to any of those three elements. Just addressing sort of the overarching.
Listen for the sighs.
themes of the defendant's motion. The defendant challenges, as he just stated, the testimony of Canton Police Sergeant Lank and his testimony attributing statements to the defendant that were made in the aftermath of Mr. O'Keefe's body being discovered in a purported deception of Sergeant Lank's relationship with the Albert family. Trooper Proctor's purported false and deceptive statements throughout the course of his testimony, and the Commonwealth's failure to elicit a purported inconsistent statement of Christopher Albert, and the Commonwealth's failure to impeach Julie Albert's testimony. Your Honor, simply put, none of these issues or stated malfeasance actually occurred before this grand jury. As it relates to Sergeant Lank, I mean, we're talking about what the defendant submits as an attachment is an incident from almost 20 years ago, which doesn't involve anyone who was at the house at 34 Fairview Road on the night when Mr. O'Keefe died.
No, but it involves their family, and it certainly goes to a long-standing relationship. If he's had a long-standing relationship with that family for 20 plus years, hello, am I in the Twilight Zone?
The statements that Sergeant Lank is attributing to the defendant were not only testified to by Sergeant Lank, and they're testified not in a deceptive manner. They're testified to by Sergeant Lank in the sense of he indicated he spoke to officers who had preceded his arrival. All of those officers also testified before the grand jury. All of those members who received statements from the defendant essentially indicating that she did it, that doesn't just come from one source. That comes from at least...
That she did it? She shouldn't say I did it. What they say that she said is I hit him. And I don't think that if someone hears a statement, they are allowed to assume punctuation. Was it a question? Was it a declaration? Was it one officer telling another officer, oh, hey, she said I hit. And by the way, we went over these witness statements at length. I'm going to just come on full screen for a second here because we went over these witness statements at length. And one of them said, when I asked Karen how he got the injuries to his face, she said, I hit him to his face. That's where that came in. Go back and watch that stream if you didn't see it. Correct me if I'm wrong. It's not a stream unless I kick myself out. I'm getting a producer. I am. He's actually going to be with me doing a show on Thursday for fun. So let's just take it back a second. He's going to say, well, they're mad that the Alberts didn't come out of the house. Well, nobody else came out of the house either. Nobody else came out either. So what does it matter if they didn't come out of the house? Because nobody else did. It wasn't just them. Go for it, Lally. Show us what you got.
Almost 20 years ago, which doesn't involve anyone who was at the house at 34 Fairview Road on the night when Mr. O'Keefe died. The statements that Sergeant Lank is attributing to the defendant were not only testified to by Sergeant Lank, and they're testified not in a deceptive manner. They're testified to by Sergeant Lank in the sense of he indicated he spoke to officers who had preceded his arrival. All of those officers also testified before the grand jury. Mm-hmm. All of those members who received statements from the defendant essentially indicating that she did it, that doesn't just come from one source. That comes from at least 5 different witnesses, 3 of them paramedics with the Canton Fire Department. Counsel posits the question of why didn't Brian Albert come out of the house? No one did. Not only out of that house, but any house. It's clearly visible in the grand jury exhibits. You have the cruiser camera footage from Officer Saraf as far as no one else in the neighborhood coming out of the house, as well as...
And by the way, I tried to look for it today and I couldn't find it because I have a busy life. But I do remember initially when this case was first reported on, and I thought it was Boston 25, and I went back to try and find that news report. But they said initially right away, within the first day or two, that the Commonwealth told the media that they had closed circuit camera, Ring doorbell footage, video of Karen Reed actually hitting John O'Keefe with her car. They told the media they had a video. Am I imagining that? But I couldn't find it today. So now he's going to say, well, nobody else came out of the house either. Yeah, exactly. Somebody gave them the leaf blower and somebody gave them the solo cups. So, yeah, it was his own yard and he was a cop. And, okay, CBS 4 said they had Ring camera footage. All right, let me see if I can find that because we've never seen that. Let's see how else he can get out of this. And he's also going by only the dash cam footage of, I think, Officer Saroff was the first one on the scene. So when did he turn off that dash cam?
Testimony from a number of different witnesses that were there and present on that morning in the dark, in a blizzard at the time that Mr. O'Keefe is found. Counsel wants to say that the Commonwealth is asking the court or everybody to sort of look the other way when it comes to these things. What I would submit is that's exactly what the defendant is doing. Look the other way, defense by obfuscation. It's essentially, it's a 3-card monte trick, card trick on the corner on the side. Look at all of this, look at this relationship, look at that relationship, conflating these relationships, sort of the distortion that I would say between what exists in social media realm and what exists in reality. That if you know someone, that automatically means that you're best friends with them, every single one of their siblings, every single person that they've ever met or socialized with. One social interaction, transforms into a long-standing 20-year relationship, all of those things. And what the defense is obfuscating from is the overwhelming evidence that was presented to this grand jury from a multitude of sources, 42 separate witnesses, 56 exhibits, over 1,400 pages of transcripts, which clearly demonstrate and indicate that the defendant, Karen Reed, killed John O'Keefe. But they don't want you to look at that. They want you to look at who texted who when and what they said and what was asked and what was promised. In reviewing the materials provided by the U.S. Attorney's Office, a couple things that I would note is, number one, they have no idea how much of a percentage of the totality of the federal materials we have. I don't know if we have 5%, 50%, 90%. I have no idea.
So now he's saying we don't even know how much of the federal evidence we have. Well, you have what they gave you is what you have. And they were a little disingenuous when at the last hearing, his associate, I can't recall her name right now, Lally's associate, got up and said, we've already been through these 3,000 pages, and we're going to say that 90% of it or something is exactly in line with the theory of our case. So, now he's going to argue maybe we don't have it all. Isn't this enough? Because not only have we heard that Google search at 2:27 a.m. on Jen McCabe's phone actually really did happen. We also know that Yuri Buchanan knew that Proctor had close ties to the Alberts before they interviewed Chris Albert. We know that Julie Proctor told her sister, or Proctor's sister, to tell Proctor that after all of this was over, she wanted to get him a thank you gift. And we know that Proctor was going to have Julie Albert babysit his toddler. And there's more to come. What more do you want, Lally?
The other part that's confounding is that it appears that these materials from the state prosecution were provided to the U.S. Attorney's Office by Mr. Yannetti or by the defendant or by defense counsel. And again, what I don't know is how much of a percentage of the total discovery from the state case was actually given and provided to the U.S. Attorney's Office in which to conduct their investigation. But it's clear from the investigation that they extensively investigated the facts and circumstances that led to Mr. O'Keefe's death. In sum, what I would submit, just as Ms. McLaughlin stated on the last date, that these materials are largely consistent with the Commonwealth's theory of the case. There is no suggestion of a third-party culprit, no suggestion of cover-up of evidence, no suggestion from the 13 civilians' witnesses' testimony that we've received, or transcripts of that testimony. All of them confirm that Mr. O'Keefe never entered 34 Fairview Road. All of it was absolutely no animosity between the individuals at the Waterfall Bar or at 34 Fairview.
And no animosity between Karen and John either. And by the way, the federal investigation is not about finding who is responsible for Officer John O'Keefe's death. That's not what they are investigating. They are not trying to find a third-party culprit here. They are investigating the investigation. So perhaps Lally's not quite sure what the feds were investigating, but they're not out there looking to find out who did it. So this is a ridiculous argument.
Fairview residents. There was no fight. There was no dog attack. There was no eyewitness to the circumstances that led to Mr. O'Keefe's death.
Okay, what? Hold on. He's saying the feds did not find any of this out? Okay, right. So
Between the individuals at the Waterfall Bar or at 34 Fairview residence. There was no fight. There was no dog attack. There was no eyewitness to the circumstances that led to Mr. O'Keefe's death. Witnesses also testified consistent a year later. They testified in the state grand jury in the spring of 2022, largely in the spring of 2022, and then largely in the spring of 2023.
except for when Proctor admitted that he had a close relationship that he hid from the state grand jury, except for that part.
For the federal grand jury, and their testimonies are largely consistent with the defendants.
Largely consistent. Not 100% consistent with what they said before, but largely.
Making declarative statements that she did it, not a question mark at the end, but clear, definitive statements on scene that she had discussed the damage.
You can't say whether someone had a question mark at the end of their statement or not. Okay, that's an opinion. That's a question of fact for a jury. So let's just. I want to hear that again.
Witnesses' testimony that we've received, or transcripts of that testimony, all of them confirm that Mr. O'Keefe never entered 34 Fairview Road. All of it was absolutely no animosity between the individuals at the Waterfall Bar or at 34 Fairview residence. There was no fight. There was no dog attack. There was no eyewitness to the circumstances that led to Mr. O'Keefe's death. Witnesses also testified consistent a year later. They testified in the state grand jury in the spring of 2022, largely in the spring of 2022, and then largely in the spring of 2023 before the federal grand jury. And their testimonies are largely consistent with the defendants making declarative statements that she did it, not a question mark at the end, but clear, definitive statements on scene that she had discussed the damage to her taillight prior to leaving Mr. O'Keefe's home on the morning of January 29th. You have a number of different statements that were alluded to by Mr. Jackson in regard to texts from Trooper Proctor's phone. Of note, there are no text messages between Trooper Proctor's phone and Julie Albert's phone, except for two no-content text messages, one from June 21st, 2020, and one from September 1st of 2020.
2020. 2 years before Officer John O'Keefe was killed. They were texting back then.
There is a discussion between Trooper Proctor and his sister because Julie Albert had provided childcare in a pinch on several occasions for Trooper Proctor's sister. Trooper Proctor also testified that Julie Albert never did that for him, never watched his kids, never had looked after his children. That essentially never happened. Lastly, get to the Google search, and I would agree with counsel in the sense that it's really no longer open for debate, but I'm not really sure why we're still even talking about this or why this is still a topic that they're pushing.
Really? Really? He doesn't understand? Okay, so he's admitting that it's not up for debate, but he doesn't understand why they're still talking about it? For the love of the traveling Mary, can anybody explain to me that? Okay, then dismiss the case right now. Why would someone who had nothing to do with this be home at 2:27 a.m. Googling how long does it take to die in the cold? Anyone? Anyone? Bueller? Anyone? Huh?
Essentially, what we have is, yes, what counsel mentions is there is one expert who was given two extractions, presumably provided by defense counsel,
Okay, so they're saying, well, we can't trust the Quantico trained FBI agent who gave that opinion because he got his evidence from the defense. Really? Is that what you really think? Do you really think the FBI didn't get their own evidence? Do you think that they're relying on something the defense gave them? Are you freaking kidding me? Wow, 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 wow.
That indicates from that particular FBI expert that the searches were done at 2-something in the morning. What counsel neglects to sort of raise and stress with the court is that there's a separate, and I forget exactly what it stands for, but an RCFL analysis of the phone in which through both Axiom and through Celebrite, and that conclusion of that expert is that the searches occurred when Ms. McCabe testified they occurred because the defendant asked her to conduct those searches at 6:23 and 6:24 in the morning. Really, the argument stops at the point of it's not, we didn't do our job to get the Cellbrite version that shows that information did not exist at the time of the grand jury. So I'm not really sure how the Commonwealth is supposed to run something through a Cellbrite version that isn't in existence at the time the grand jury is conducted. It's a subsequent version in which their expert, Mr. Green, finds these purported search without looking at the cache files, without looking at the DB list, without looking at the SQLite database, without looking at the wall file, all of which was done not only by Trooper Garino, an independent expert named Jessica Hyde, which counsel has.
Because Trooper Garino is far more educated than the Quantico trained FBI specialist who specializes only in this. So, but on the other hand, the actual software to do the job that they did now wasn't invented yet when we did it. So, you know, maybe we were wrong, but it's not our fault, Your Honor.
As all of that, as well as the senior technical analyst from Cellbite itself, a man named Mr. Whiffen. Counsel's had this report for months at this point. And essentially, Mr. Whiffen is essentially the person who creates the software that all of these experts are using. And his definitive opinion indicated in his report is that Ms. McCabe conducted those searches at 6:23 and 6:24 in the morning. So I would agree with counsel that it's really no longer up for debate. I think we just disagree as to the conclusions of that.
There were 3 searches. 3. Count them, Lally, 3.
But based on the totality of the evidence and what I would submit as the overwhelming evidence that was presented to this grand jury, all of these sort of individual parsing of stated malfeasance simply doesn't even come close to sustaining the burden under Odell. And for that reason, I would ask that the court deny the motion to dismiss.
Okay. Do you want a few minutes, Mr. Jackson, to respond?
Very briefly.
Okay.
Oh, this is good. This is
First of all,
this is okay. Okay, this is like so good.
it's always interesting to hear an argument that suggests there's nothing to see here. And that's exactly what Mr. Lally did yet again. He said, look the other way, look the other way. Oh, it's the defense that wants you to look the other way. We don't want you to look the other way, Your Honor. We want you to look directly at the evidence of the compromised relationships that Trooper Proctor had and hid. That's what we want the court to look at. He suggests, oh, well, there's just a couple of text messages. It's no big deal. It's a couple. The fact is, Your Honor, she really hit him. She really hit him with the car. Let's remember, she really hit him. And these text messages, they mean nothing. We're talking about the integrity of a sitting grand jury and the presentation before that grand jury. What Mr. Lally now has in his possession, but he didn't mention, now that he says, oh, well, she killed him. Let's just get on with it. She killed him.
This is so amazing that he saved this for rebuttal. This, like I said before, this is a masterclass in lawyering because he saved this nugget for rebuttal because he wanted to see if Lally was going to bring this up in his argument. And of course he didn't. So this is how it's done, my friends. This is a masterclass in trial lawyering. I'll make him bigger again, but I just had to tell you that. Listen up.
He's already tried and convicted her in his mind and tried to do it in this courtroom. It doesn't quite work that way. Now Mr. Lally has in his possession another thing from the feds that we didn't have access to. The federal investigators hired, independent of us, we had no idea, an independent of the Commonwealth, hired a professional reconstructionist, 3 PhDs, to look into exactly this issue. Did Karen Reed's car, did her SUV make contact with John O'Keefe? And their conclusion to a person was his injuries were inconsistent with the damage on the car. The damage on the car was inconsistent with having made contact with John O'Keefe's body. In other words, the car didn't hit him and he wasn't hit by the car. Period. Full stop.
Period. Full stop. If you saw my thumbnail, you know where I got it from. And this is what I've been saying all along. As an accident attorney of 30 years handling dog bite cases, accidents, car accidents, motor vehicle accidents, all kinds of accidents. An accident reconstruction expert hired by the feds. An independent expert in accident reconstruction said John was not hit by a car and a car did not hit John. And I am feeling validated right now because this guy had 3 PhDs. And you may recall, according to a TV appearance that I was on, when an former FBI spokesperson, former FBI agent, who's now a talking head on a lot of news channels, said, when I said that this was not caused by a car accident, said, oh, I love how everyone who doesn't have a PhD thinks that they know where these injuries came from. I feel personally validated today. And that's all I'm going to say. I'm going to let him talk.
That's their independent expert, not ours, not somebody on our payroll like Mr. Whiffen or one of their experts or Trooper Guarino, who's an arm of the agency. This is an independent federal government witness or series of witnesses who say unequivocally, that car did not hit John O'Keefe and John O'Keefe was not hit by that car. But he didn't mention that. Second, he argued that the texts were not, these aren't texts between Julie Albert and Michael Proctor. These are texts between his family members. And then he mentions these 2 texts that had no content. What are the chances that Michael Proctor sent Julie Albert texts with no content? Your Honor, it's not that they didn't have content, it's that it couldn't be recovered, which sometimes happens. But we do have evidence that they were in fact in communication with each other as early as 2020. And with regard to the 2:27 a.m. search, it's not a 3-card Monty. It's not a shell game or whatever other fanciful thing Mr. Lally wants to suggest that it is, as he tap dances his way around this. He says that our expert, Rick Green, didn't look at the SQLite database. Yeah, Mr. Lally, reread his report. Yes, he did. He didn't look at the wall file. Yeah, Mr. Lally, reread his report. Yes, he in fact did. And he's the one that found the 2:27 a.m. search. And with regard to the Regional Computer Forensics Lab, that's the definition he couldn't remember. What they actually said was, because Mr. Lally got this wrong too, what they actually said was, yes, there was a 6:23 and a 6:24 search. And there was a 2:27 a.m. search as well. All 3 of those searches existed in the phone, Jennifer McCabe's phone, and it's not up for debate. That wasn't presented to the grand jury. The information that we've been talking about today wasn't presented to the grand jury. We're talking about the integrity of a proceeding. He doesn't get to convict my client by standing up here and pounding the table and saying, oh, she did it, she hit him. So let's just all get on with it. Deny this motion. We're talking about the integrity of what is the foundation of Massachusetts' judicial system. And that integrity was compromised, that integrity was impaired. And it demands that justice be done. And that justice is in the hands of this court. We ask this court to do what the evidence dictates, do what the law dictates, and that is dismiss this indictment. That is the only way justice will be found in this case. Thank you.
All right. Thank you very much. Mr. Yannetti, are you all set?
Yes, Your Honor, thank you.
Okay, let's take a break before we listen to Mr. Yannetti. Dun, dun, Go to the chat. Hello, Brian. Thank you for the 2 beans. Can't wait to hear an attorney's take. Thanks. Go check out Brian's channel, LTL2 Crime. He does a great job on a lot of different things. Thanks, Dino's Ghost, for your super chat. Please explain how it isn't dismissed already. I don't think she wants to be the one to do it. That's my personal opinion. And we'll finish off today, and then you can tell me what you think. I think she wants a jury to do it because I don't think she wants to be responsible. Amy, thank you for being a member for 4 months. My heart broke for John's mother. Yep, mine too. It's always about the victims and justice for John O'Keefe. And John O'Keefe is the victim here. Officer John O'Keefe, who is a brother in blue, by the way. Hello, Miss Mojo Rise, and thanks for being a member for 3 months. And hello to you. And Kate became a member. Thanks. Welcome, Kate. Stephanie wants to know if they're trying for dismissal with or without prejudice. If the indictments are dismissed, it would be with prejudice, meaning they can't bring it again. If the DA is disqualified and a new or a special prosecutor is appointed, they may have to re-indict and bring the charges again. Depends on the rules of the law of Massachusetts. So I don't know if that answers your question, but with prejudice is always the best because that means they can't bring new charges. That would be over. Lindsay Tyler, question, Melanie, if this goes to trial, with the FBI experts who investigated some of the things they're going to talk about testify in front of the jury, they absolutely could be called to testify. Absolutely. We're talking about the expert that the feds hired for this investigation of the investigation. Yes, they could be called to testify. They could be subpoenaed. All right, we're not going to just talk about that person. Casey, today, thanks Casey for your super chat. Today had the wow factor. Yes, it did. Rosie, she who laughs last laughs best. And Marta wanted to know if there's a grand jury here's only from one side. Yes, it's only the prosecution side, and they decide what to show, what to ask, what witnesses to call. They run the show. The defendant is not there. The defense attorney is not allowed in, and it is secret. Wicked Psych, thanks for the super chat. Rewatch the Murdoch case. It shows the prosecution's allowed to lie whether the defendant is guilty or not. I did watch that case. I was riveted by that case, in fact. Jackie McGee, I have a good comeback for the people who try to say you aren't a doctor to say the marks were dog marks. Guess what? There won't be all doctors on the jury either. Good point. Wicked Psych, thanks again. I don't know if Murdoch was guilty or not, but I know the lead prosecutor lied to the grand jury, and I had a huge problem with that. Yeah. Thank you again for another super chat. Amy, hello. Amy, thank you for the super chat. Hi, beautiful. Attorneys have an ethical obligation to dismiss bogus charges. If they know they are bogus, can they be disbarred? Marcy might be the one in trouble here for making that statement. And I don't know how deep Lally's involved in this, and I can't speak to whether or not he knew that it was bogus. We don't even know yet that it's 100% bogus. I mean, the district attorney works with the evidence they're given from the law enforcement. Let's just say that. And if that's tainted, then the taint goes all the way through. Wicked Psych said, maybe the judge was directed to let it play out to see how deep any corruption runs and who is involved. Maybe. Kirsten says, what type of lawyer are you? Love your comments. I was a civil litigator for 30 years handling mostly the biggest cases that I handled were the sex abuse cases against the diocese here on Long Island for all of the survivors and victims of clergy SA, as we have to say on YouTube. But in addition to that, my firm handled all kinds of accident cases, including medical malpractice and crane collapses, construction accidents, car accidents, dog bite cases. So, I mean, that's the stuff we handled throughout. So litigation, civil litigation. Hi, Stacy. Thanks for being a member for 3 months. Take that, Jen, like butter. Maureen became a member. Thank you, Maureen. Louisiana. Louisiana girl, how in the travel and Mary is this going forward? I don't know. But thank you, Maureen, for the Cash App. I really appreciate that. And also, somebody else sent me a Cash App, and I think I already thanked you earlier. But I want to show you a little bit because of what we just saw. We're going to go back to something that's just like too good not to like show again. So we're going to show it. This is when I was on Court TV. This is the quote that we were just talking about. And this was my court TV appearance from, I think it was January 5th, 2024, I want to say, around there. Thought I wrote it down on this little slip of paper here, but maybe I didn't. So let's start here, shall we? Well, that's me again. Hold on. Come on. Come on, you little bugger. We're already 39 minutes into this show with Vinnie Politan. And if we have so many questions from looking at these facts, I think a jury's going to have a lot of questions too. That was right after I talked about the autopsy photos to John's arm and how I thought that they were caused by a dog.
Jennifer, which case is easier to prove?
Oh, without a doubt, the case that he was hit by Karen Reed. She had the motive. These are not dog scratches. That has been said by two medical examiners, separate medical examiners that examined him. Also, there were samples sent to a lab in California to test for non-human or canine DNA. Negative. So
this was in January. Nobody knew that. Nobody knew that. She knew that. It wasn't tissue samples that were sent to California. It was swabs from his clothing that wasn't turned into evidence for weeks because somebody had it. Proctor.
So I find it so interesting that people want to look at a picture and all of a sudden they're medical examiners, they're doctors with PhDs, and they can say these are dog scratches.
Doctors with PhDs. Oh, you mean like the Quantico trained, or no, the accident reconstructionist with 3 PhDs who just said he didn't get hit by a car? So are we going to say that since he has 3 PhDs, we're going to agree with his opinion now? Okay.
Second to the point there, the Brian Albert, they sold their house months and months after that. Also, they had a leak downstairs in the basement.
She knew a lot of things that nobody else knew, but I want to bring it to the end here. 4350.
Really have like a minute. So each one of you, like, give me 10 to 12 seconds. What do you believe is the most important piece of evidence, and one line as to why? Jennifer.
Most important piece of evidence is that broken taillight on the scene and his DNA on the bumper.
Melanie.
I'm going to say the most important piece of evidence are the photographs of the autopsy. I've handled hundreds, if not thousands, of motor vehicle accident cases during the course of my 30-year career as a civil litigator. And those are not injuries that happen from a pedestrian versus car backing up into you at a low rate of speed. They're just not.
Peter.
And today, I feel validated by somebody who actually really does have 3 PhDs, an accident reconstructionist that was hired independently by the federal government, who said he was not hit by a car and those injuries did not come from a car. There you go. And then last night, Brian did a stream about LTL True Crime podcast that was done in February, where I'm sorry, I don't know her name. It's called the Outlier Podcast. And she interviewed Jennifer Koffendorfer, and she had some interesting things to say about me, I think. She didn't name me. I'm pretty sure she was talking about me. I'm going to cue that up for us to talk about later. Just listen to the audio on that because it's super interesting. I wonder if her opinion will change now that there's an actual FBI Quantico trained expert looking at the cell phone data. We'll see. All right, let's get back to the motions hearing because now it is Yanetti's time to shine. Lauren Conlon. Is that her name? Lauren Conlon.
So the same time, and let's see how you do with it.
We believe our witnesses. They are telling the truth. Karen Reed is guilty. Any suggestion to the contrary is a desperate attempt to reassign guilt. Can you imagine a district attorney with a sworn duty to do justice and respect the presumption of innocence issuing such a statement in a pending case? Before August 25th of 2023, I could not. Yet that was the message of Norfolk County District Attorney Michael Morrissey to potential jurors in this case on that date. I've been practicing criminal law as both a prosecutor and a defense attorney for over 30 years now. Never have I seen such unethical conduct from a prosecutor. I know of at least one law professor who used Mr. Morrissey's statement in his class to teach his law students how a prosecutor should not act. Another member of the bar.
Wow. A law professor used Morrissey's speech in his class to teach law students how a prosecutor should not act. That's huge. Just saying.
Has already reported Mr. Morrissey's conduct to the BBO. And now we are here with a motion to disqualify Mr. Morrissey from further prosecuting this case because he has a personal interest in the outcome. Your Honor, this court should grant our motion to disqualify. And at the outset, I note that we've also moved for sanctions, dismissal of these indictments as a result of his misconduct. But we have so many additional grounds for dismissal as a result of the material provided to both sides by the federal authorities that we will be filing a further motion to dismiss for extraordinary governmental misconduct. My co-counsel has spoken to that previously. To the extent that the court entertains our motion for sanctions, specifically dismissal as a result of his egregious.
Can I just interrupt there and ask you, are these going to be the same motion essentially?
No. There's information and evidence that's been provided by the federal authorities which deals with the egregious conduct of both the district attorney and his investigators and the police. That will be the subject of a separate motion, Your Honor.
So I thought that was going to be your supplemental memo to this.
That's huge. That is a huge motion. There's so much more evidence that the feds have to say that what the DA and the police and the investigators did was so improper. He needs to make a whole new motion. And she's saying, oh, well, I thought you were going to supplement your motion and just like respond to that other motion with all of that evidence. It's 3,000 pages worth of evidence, Your Honor. Can't possibly argue that today. I need to make a whole other motion because of the egregiousness of the prosecution and the district attorney's office based on new evidence that was handed over to us by the feds.
This motion. It sounds like it's the same issue, Mr.
No,
Kennedy.
it's not. And what I'm saying to the court is I have limited time.
When I interrupt you, I stop the time.
Well, I appreciate that. But even with that, Your Honor, the focus of my argument is going to be on the disqualification as opposed to the dismissal. I've submitted papers on the dismissal. I will rest on those papers with regard to that issue. That's my only point.
All right. So when you file the other motion, I need you to include in your memo how that's different specifically from this.
Understood.
Not just the remedy, but how the basis of
Understood.
it is different.
Understood.
All right. So I'm going to start you again from
Right. And if I don't agree with you that the basis is different, then I'm not going to consider it because it's not timely. That's what she's setting that up for.
scratch. Go right ahead.
I appreciate it. Well, Your Honor, this case admittedly has been an unusual one for a district attorney to deal with. The district attorney's office is not accustomed to a criminal defendant fighting back in the way we have prior to trial.
Right.
What usually happens when the prosecution brings charges is they detail the allegations at an arraignment in court. And as a result, their narrative and theory of the case becomes widely reported while the defendant and the defense team remain relatively quiet. After arraignment, moreover, the media typically lose interest and wait until a trial or potential resolution of the case before they start reporting on the case again. And in this way, the district attorney's office is quite accustomed to always controlling the narrative in pending cases, at least until the defense makes an opening statement at trial. And as long as the prosecution gets to control the narrative in the press, they have no problem with what's being reported. But of course, this case has been different. Their control of the narrative did not last very long here. In our view, it became clear very early on in this case that their narrative was wrong. Their theory of the case was wrong. Their allegations did not fit with the evidence that we fought so hard and for so long to get access to over 2 long years. So along the way, we spoke out about our findings of exculpatory evidence, mostly within this courtroom, but occasionally outside. The DA was not used to that and apparently didn't like it because they initially sought the extraordinary remedy from this court of trying to gag the defense from exercising our First Amendment rights to discuss a client who at all times is presumed to be innocent. And as you know, they filed that motion on June 9th of 2023, and it didn't work. The court denied the motion, specifically ruling that any statements attributed to counsel could generally be characterized as responses to the accusations against Ms. Reed and are therefore permitted under the rules. When you made that ruling, though, Your Honor, you admonished both sides that commenting on the credibility of witnesses would have a prejudicial effect on the proceeding. And at that point, we largely stopped making extrajudicial statements. By contrast, Norfolk County District Attorney Michael Morrissey, only 25 days after that court's ruling, instead decided to blatantly ignore this court's admonishment. DA Morrissey went off the rails, gave an unprecedented video statement to the media where he specifically vouched for the credibility of Commonwealth witnesses in violation of the rules of professional responsibility, in violation of this court's order. A member of the public issued a public records request, and we got this to show all of the media outlets that DA Morrissey made sure received his statement. Before any trial has occurred, he called the defense theory in this case, quote, a false narrative. Before any trial has occurred, he announced his opinion that nobody within the home at 34 Fairview participated in any murder or any cover-up. Before any trial, he vouched for the credibility of Commonwealth witnesses Jennifer McCabe, Matthew McCabe, and Brian Albert. He announced that those witnesses were forthcoming. In other words, truthful. Before any trial has occurred, DA Moore.
I feel like I'm in church going, that's right. That's amen. Amen. Say it, brother. Say it. We went over this, I think, several streams. We've gone over Morrissey's statement and watched it. I think last time was the last time. So if you haven't seen it, go watch it because it is egregious, the things that he said to the public. And he didn't go on TV and hold a press conference with actual reporters to take questions. He videotaped this in his conference room in front of a wall of law books and talked about how there was a false narrative, the Karen Reed case, and how all those people in the house did nothing wrong. And I've never seen anything like it, and neither has he. And a law professor is using it in class to teach his students in law school how to not be a prosecutor. That's rich.
Morrissey announced that the defense theory is, quote, a desperate attempt to reassign guilt, end quote. Given those broad statements of Mr. Morrissey's opinion that Karen Reed is guilty, can you believe that the DA in their opposition to this motion had the audacity to claim that DA Morrissey's words were narrowly tailored to the harassment of witnesses? It goes without saying, but your words are not narrowly tailored if you're a prosecutor vouching for the credibility of witnesses, particularly after a judge told you not to do that. Your words are not narrowly tailored if you're announcing to the public that you've already assigned guilt to a criminal defendant before trial. A desperate attempt to reassign guilt. DA Morrissey announced to every potential juror in Norfolk County, not that someone charged with a crime is innocent until proven guilty. The words innocent until proven guilty never came out of his mouth. Instead, he announced his office had already assigned guilt to Karen Reed. So in his view, when she fought back by reasserting her right to be presumed innocent, he deemed that a desperate attempt to reassign guilt. Never in over 30 years of practice have I ever witnessed an elected DA so blatantly violate the rules of professional responsibility. Never have I witnessed an elected DA trample on the constitutional rights of a criminal defendant who enjoys the presumption of innocence. And I do have some perspective in this area. I had the privilege of spending the first 10 years of my career as an assistant district attorney in Middlesex County. I had the privilege of working with and for some of the finest DAs this Commonwealth has ever seen, from Scott Harshbarger to my mentor, Tom Riley, to Martha Coakley, Jerry Leone, Marion Ryan. In addition, I worked with some of the finest Massachusetts state troopers acting as homicide investigators, men and women I respect for their integrity and prowess as ethical investigators. In a million years, I could not imagine any of my former colleagues and bosses making such a statement. They were professionals with ethics and a humble respect for the awesome power they possessed as public prosecutors. So for those reasons, in some ways, it pains me to have to file a motion like this. But DA Morrissey, through his poor and unethical decision-making,
It pains me to have to file a motion like this. It pains me.
to release a video statement designed to prejudice potential jurors against my client has forced my hand. So the question then becomes, why did he do this? Why did he take such a personal interest in this case, such that he would take the unprecedented, and that's his word, unprecedented step of vouching for Commonwealth witnesses? Why would he take the unprecedented step of denigrating the defense theory to potential jurors? The unprecedented step of announcing to the public that Karen Reed is guilty? Why would he trample over the presumption of innocence and announce that we're trying to reassign the guilt that he's already assigned to her? Well, on December 4th of 2023, we began to learn why. That was when the DA released to us correspondence he had had with the U.S. Attorney's Office, which dated back to May of 2023. That correspondence revealed that federal authorities were investigating this case. And it's worth noting, they only released those to us once Fox 25 had succeeded in a public records request, and they knew what they had kept hidden was going to be revealed. And once we got those letters, we learned why they wanted them hidden. We learned that in May of 2023, the DA's office knew there was a federal investigation. They did not reveal that knowledge to the defense. In fact, on June 12th of 2023, the acting U.S. attorney specifically told the DA's office they could reveal the existence of this federal investigation to us, but they didn't. They kept it secret. And then worse, Your Honor, on December 4th of 2023, the district attorney's office provided a false notice of discovery to this court and to the defense. In that notice of discovery, they claimed they had received no confirmation that any witnesses had testified before a federal grand jury.
Okay, this is going to get better now, because this is a major false representation to the court. I would go so far as to say it could be perpetrating a fraud on the court. That's me, my hyperbolic way of legal writing. He's not going to go as far as I am, but listen to this.
We now know that was a lie. We know it's a lie because 7 months earlier, DA Morrissey wrote that multiple state witnesses had received subpoenas. We know that was a lie because now that we've got the information from the feds, Nicole Albert testified before a federal grand jury that she participated in a group conference call with Jennifer McCabe, Matt McCabe, Brian Albert, ADA Lally, and victim witness advocate Stephen Nelson, a group conference call before she testified before the federal grand jury in July of 2023.
What? What? Julie Albert was on a conference call? No, I'm sorry. Nicole Albert testified? I got to take that back.
Lie. We know it's a lie because 7 months earlier, DA Morrissey wrote, got the information from the feds. Nicole Albert testified before a federal grand jury that she participated in a group conference call with Jennifer McCabe, Matt McCabe, Brian Albert, ADA Lally, and victim witness advocate Stephen Nelson, a group conference call before she testified before the federal grand jury in July of 2023.
What? Nicole Albert testified in front of the federal grand jury. that she was on a group conference call with Lally, a victim's advocate, Jen McCabe, Matt McCabe, Brian Albert, on a conference call before testifying in front of about what? About what she was going to testify to? Lally was prepping her for her testimony. Are you freaking kidding me? Do you know how improper that is on its face in and of itself? Forget that they lied about it. Having a conference call with witnesses that are being called to testify in front of a grand jury about the investigation where they're investigating the DA's office and all of law enforcement that investigated Karen Reed's case. And they're having a little powwow before their testimony with the actual DA's office. This is just one of the other bombshells that were revealed today. That is insane.
We also know it was a lie because he wrote in his letter, and I quote, "We have confirmed that witnesses testified before the federal grand jury." Yet 7 months later, the DA's office tells this court that it had received no confirmation. That is outrageous. We are outraged that he lied to us.
Wait
This
for it,
court
wait for it.
should be-
Wait, I love how he like leans in. This is like also an acting class, you guys. Look how he leans into the mic, lowers his voice to make his point instead of screaming to make his point. This is like something they teach you in acting class too. Listen up.
Because he wrote in his letter, and I quote, "We have confirmed that witnesses testified before the federal grand jury." Yet 7 months later, the DA's office tells this court that it had received no confirmation. That is outrageous. We are outraged that he lied to us. This court should be outraged that DA Morrissey lied to you. In a prior hearing in this case, I argued to this court that the letters back.
And the Oscar goes to David Giannetti in The Commonwealth versus Karen Reed. Best supporting actor.
And forth confirmed that DA Morrissey believed that he personally and his office in general was being targeted by the U.S. Attorney's Office. I chose my words carefully. I never said he received a target letter. The existence of a target letter is irrelevant. The inquiry is, what does the DA know and believe?
That's
And
right.
he revealed in those letters what he knew and believed. He revealed that he believed that U.S. Attorney Rachel Rollins had a personal animus against him. He wrote, quote, "She's made no secret of her personal animosity towards me." He also wrote that the head of the public corruption unit at the U.S. Attorney's Office may be personally retaliating against him and targeting him because his wife was unhappy with the way the Norfolk DA treated her. He wrote, in short, that he knew, felt, and believed that he and his office were being targeted. Now, why is that important? It's important because of the immense power that a prosecutor has. It is important because we need an unbiased prosecutor with no vested interest in a case to try to administer justice based on the evidence and not based on any personal interest in a case. It is important because, in the words of U.S. Supreme Court Justice Robert H. Jackson, quote, "We must have assurance that those who wield this power will be guided solely by public responsibility."
So I just want to tell you, you've gone over your time. I see you're reading, so you have some idea on how much longer you have. How much longer do you have with that?
Probably about 3 minutes, Judge.
Okay, yeah, go ahead.
Thank you. Indeed, you're
And the best is yet to come. I think that's a song too, right? 3 more minutes is all it's going to take to make this next bombshell of a point.
Your Honor, Justice Jackson practically spoke to DA Morrissey from the grave. The prosecutor has more control over life, liberty, and reputation than any other person in America. His discretion is tremendous. He can have citizens investigated, and if he is that kind of person, he can have this done to the tune of public statements and veiled or unveiled intimations. Or the prosecutor may choose a more subtle course and simply have citizens' friends interview. Prosecutor can order arrests, present cases to a grand jury in a secret session, and on the basis of his one-sided presentation of facts can cause the citizen to be indicted and held for trial. Well, while the prosecutor at his best is one of the most beneficial forces in our society, when he acts with malice or other base motives, he's one of the worst. In his own words, DA Morrissey revealed he has an interest in this case that goes beyond the interests of justice. He revealed that he knew that his office was being unfairly targeted and investigated. And it doesn't matter if his belief or knowledge was right or wrong. It's only important that he believes it. And this means he has a personal interest in getting Karen Read convicted. If he can use whatever means he has at his disposal to convict her, and he succeeds, that would vindicate him and harm the federal investigation of his office. On the other hand, if she's found not guilty, as we expect she will be, he knows that he and his office will remain in the crosshairs of the federal investigation. And it's important to note, Your Honor, both sides have been made aware multiple times that as we have this hearing today, that federal investigation is still open. They've called most of the Commonwealth's witnesses to testify, but they're not done. DA Morrissey has an interest in this case not to do justice, but to win. That's why he hid his knowledge of the federal investigation for 7 months. That's why he slow-walked discovery. That's why he gave a lengthy video statement saying Karen Read is guilty. That's why he talked about our theory being a desperate attempt to reassign guilt. And perhaps that's why, in contravention of Judge Krupp's preservation order, DA Morrissey's office gave the go-ahead to Brian Albert and Brian Higgins to destroy or dispose of their phones. We only learned that because the federal authorities revealed that in their investigation.
What? Did you hear that? The DA's office gave Brian Higgins and Brian Albert the go-ahead to destroy or dispose of their phones. And that is something that the FBI found out during their investigation. And does that explain why Brian Higgins allegedly came into the state grand jury? Or was it the federal grand jury? Now I can't remember. With printed out text messages between him and Karen Read? Came in with a stack of printed out text messages, or somebody did, because the DA said, gave him the go ahead to dispose of your phone. Brian Albert, whose house Officer John O'Keefe was found dead on the front lawn of, who was a Boston police officer, and Brian Higgins, who was inside the house that night, who's an ATF agent. The DA's office gave them the go-ahead to dispose of and or destroy their phones. Anyone? Anyone as outraged as I am? Oh my. So Ms. McLaughlin, I think that's her name, the associate of Lally, when you said that of the 3,000 pages that you read that were turned over to you by the feds, when you said that 90% of that was, or 95% of that was in your favor and in line with your theory of the case, did you forget about this part? Or did you not have a chance to see that? And it gets better, because not only did they dispose of their phones, here's a reason why they might have disposed of their phones.
And I'm just about ready to end. The DA also, as my colleague has indicated, the FBI has confirmed that Jennifer McCabe Googled, how long to die in the cold at 2:27 in the morning. But what has not yet been mentioned is that 5 minutes before that, Brian Higgins and Brian Albert were calling each other at 2:22 in the morning on January 29th after previously testifying they were both asleep at that time.
What? Bam! They testified they were both asleep at that time, and 5 minutes before she Googles how to die in the cold, Brian Higgins and Brian Albert were calling each other on the phone. They lied. They lied and said they were asleep. And now the feds dropped the bombshell. Boston MA 781 says, imagine the evidence that would have been revealed if they had all day. More to come. Oh my.
There was a lot of suspicious activity in in the early morning hours of January involving the witnesses that Morrissey improperly announced to the public were telling the truth. We're getting to the bottom of it, and the truth will come out. But as we continue to defend her, Your Honor, like any criminal defendant, my client deserves a neutral, impartial prosecutor interested solely in justice with no vested outcome in this case. And it's crystal clear we do not have that in Michael Morrissey. That is why he should be disqualified from this case. And that is why I urge you to do just that in the interests of impartial justice.
All right. Thank you very much. Who's arguing this? You, Mr. Lally? All right. So let's start with 10 if you need more.
All right. Okay. All right. I'll take that under advisement. Mr. Lally, what say you? What say you, Mr. Lally? Oh man.
Thank you, Your Honor. And again, I don't think I'm going to need much more than that. Again, I know the court has reviewed all the materials, and I know the court is well aware of the standard, and it's a standard which I would submit just simply hasn't been met here. To characterize counsel's actions in this particular proceeding with specific reference to the media and saying it's different, I think is minimization to the highest degree. Essentially, what the defendant is positing, or what counsel is positing in this motion, is that due to a recorded statement by the district attorney over 6 months ago, that impinges on her right to a fair trial, or it impinges, shows some sort of deleterious motive on behalf of the district attorney in the handling of this case. The statement, as the district attorney indicated in it, was in response to an extraordinary degree of relentless and really relentless harassment and intimidation of nearly every witness associated with this case, which included a July 22nd rolling rally of nearly 100 people traveling to witnesses' homes and calling them murderers. That is largely what this was in response to, and is in complete conformity with Massachusetts Rules of Professional Conduct 3.0.
But look over here, Your Honor. Look over here. I got something shiny for you over here. I got somebody who's not a defendant in the case, or doesn't work for the defense, and is not an attorney for the defense, holding a rolling rally. So let's look over here, everyone. Nothing to see here where the DA told Brian Higgins and Brian Alberts that they could destroy their phones. Nothing to see here when they said they were asleep and they were really talking to each other on the phone. Let's look at the rolling rally. And that's
6B6 that permits an attorney to make a warning of danger concerning the behavior of a person involved when there is reason to believe that there exists a likelihood of substantial harm to an individual or to the public interest. It's also in conformity with Rule of Professional Conduct 3.6.
See, he says, somebody said, what does this have to do with anything? He's defending Morrissey making that statement. He's saying Morrissey had every right to make that statement because these people were being harassed and intimidated.
C, which allows for such statements to rebut the prejudicial effects of the defendant's and her counsel's misconduct. Now, again,
that misconduct had nothing to do with the defendant or her counsel. So unless you have some proof of that, Mr. Lally, you better walk that back.
No, the court has read through the Commonwealth's opposition, but just to highlight a few of those particular incidents. So yes, the July 31st, I believe, was the ruling in regard to the, for lack of a better term, a gag order. And I think it's been somewhat inappropriately or just patently falsely represented to this court in public what that ruling said. It indicated.
Now you're going to tell the judge that she didn't mean what she said in her ruling, that she carved out an exception for Morrissey to be able to talk to the public? Really? Are you going to really do that, Lally?
That the statements of counsel arguably cross the line of permissibility under Rule 3.6, and that meaning defense counsel. that the inflammatory statements about the Commonwealth and witnesses, particularly by Attorney Jackson, appear to have fueled much of the publicity in this case. And that's a quote from the court's ruling. And that the defense counsel did not have carte blanche to speak with the media, and going forward, defense counsel should ensure that their statements are limited in conformity with the rules. And it denied the Commonwealth's request for that gag order at this time, denying it without prejudice. And then Mr. Yannetti wants to get up here and say that they largely stopped making extrajudicial statements after the court's ruling. And so I guess largely stopping would then include August 22nd, the day before the district attorney's statement, a ABC News broadcast in which Mr. Yannetti and Mr. Jackson were featured for an
Okay, so did Morrissey make his statement in retaliation for the witnesses being intimidated by the rolling rally, or because he wanted to get 9 minutes on TV like they got 9 minutes on TV? I have news for you, Mr. Lally. When a district attorney speaks to the public, their statement is given a lot more weight as a public official, as an elected official, as someone in a position of power and respect than a defense attorney and a defendant. So which is it? Did he get on there to refute the rolling rally and the witness intimidation that had nothing to do with the defendant and her counsel? Or did he get on there because he wanted his 9 minutes?
9-minute, 37-second segment
37
in which Attorney Jackson indicated that pieces of taillight were planted after the fact, that the victim walked into the house. I think he was confronted, was likely brought down to the basement. I think the confrontation got physical and he was beaten to a point of unconsciousness, that he had defensive wounds, bruises on the back of his hands, largely of which is all not only not true, but directly contradictory to the vast amount of evidence that has been turned over in this case. Mr. Jackson then went on to continue that this was a cover-up, and indicating that John was murdered inside that house, his body was placed outside. This also continued into September. September 17th, the defendant, traveling with Attorney Jackson, Attorney Little, and a woman believed to be a television news producer, to the victim's home, to Mr. O'Keefe's home, in direct violation of her conditions of release, where she has to stay away from, as well as other places of interest and sort of tour around the town of Canton. When balancing the amount of public and prejudicial statements made by the defendant and her counsel, the Commonwealth would suggest that then characterizing the district attorney's statement from over 6 months ago, threatening her right to a fair trial, is simply a position that's just untenable. Now, in context, as far as those particular statements, those particular actions go, as the court is well aware,
That's John O'Keefe's mom, for those of you just tuning in or who do not know.
there is a significant history between this defendant, Mr. Yannetti, Mr. Jackson, and the social media blogger, Mr. Kearney, who's now been indicted for intimidation of witnesses in this case. And with reference to that, there is a significant, despite public indications to the contrary, that indications from Mr. Kearney's phone, which was seized, is that there is a precipitous amount of phone communications, indications of
Who cares? Who cares who he spoke to? He's not a party to the case. And Karen can talk to whoever she wants. It doesn't matter. But look. Aiden Carney, look over here.
communications between Mr. Kearney and Ms. Reed on a signal messaging app, an encrypted app, as well as, I believe, about 189 phone calls over a span of a few months. And that's just what's indicated or contained in the phone. There is also, going back to the spring of 23, direct communications between Mr. Kearney and Mr. Yannetti and Mr. Kearney and Mr. Jackson. They went out to lunch with Mr. Kearney following a court date in May of 2023.
A meal.
And this is a person who counsel in the memo seems to want to distance themselves from, based, I'm presuming, on subsequent indictments. But
What?
the truth is in the phone. The phone doesn't lie as far as those communications.
The truth is in the phone. The phone doesn't lie. Unless it's John McCabe's phone. Then the truth is not in the phone. Unless it's Officer John O'Keefe's phone saying that he walked 3 flights of steps. Then the truth is not in the phone. But for purposes of this argument that I'm going to make right now, the truth is in the phone. How can anybody take this guy seriously, really? How can anybody take this guy seriously? Because all you got to do is play that sound clip, and that's it. The truth is in the phone.
Themselves from, based, I'm presuming, on subsequent indictments. But the truth is in the phone. The phone doesn't lie as far as those communications are concerned, as far as those communications between counsel and between the defendant.
Okay, so the truth is in the phone. The phone doesn't lie. You hear the sirens going off. Somebody call the cops because we've been robbed. We've been robbed. You couldn't even get that statement in without the sirens blaring in the background. It won't even be a clean sound clip. Did you plan that? The truth is in the phone. Except when I don't want the phone to be truthful. Then I'm going to argue against what's in the phone. But for purposes of my argument right now, with Turtle Boy and Karen's communications, the truth is in the phone, which has nothing to do with anything, which is not a germane issue in this case, which is not going to go to guilt or innocence.
In this particular case. So to say that this is a different case, again, I would suggest is a large minimization of what actually has transpired here. Lastly, what I'll say in reference to the federal grand jury, what is also clear from the federal grand jury is that this was an investigation which was initiated by the defendant and Mr. Yannetti. So to claim...
No, you're saying the federal investigation was initiated by Karen Reed and Mr. Yannetti? Really? Is that what you think happened? Dave Yannetti picked up the phone and said, hey, FBI, we think you should investigate this. Come on, please. He's making this argument with a straight face, really? Is that how it works in Massachusetts?
Claim that he was in the dark or didn't know about this federal investigation. Every bit of discovery that the federal government has from the state case was provided by Mr. Yannetti. Nothing was asked for from the Commonwealth. Nothing was asked for from the district attorney's office.
They don't need to ask you for anything. They're the FBI. He doesn't get it. They don't need subpoenas. They don't need motion practice. They don't need to ask you for anything. And that's why Marcy was so pissed, because he wanted to know what was going on and nobody would tell him. And you're having conference calls with witnesses in this case before they go testify in front of the federal grand jury. I can't even believe you were able to get back up and show your face in this courtroom, sir.
Office, the state police. So again, what I was intimating before in reference to the motion to dismiss, I have no idea what they have seen or what they haven't seen, how much of the file, how much of the discovery or anything else. It's all sort of been provided and colored by Mr. Yannetti. And this goes back to November of 2022. So to then claim that you were sandbagged or didn't know about an investigation that you initiated over a year before.
Here's the thing, Lally. You're required to notify them. You can't get around that fact.
Until late in December of 2023 is, I think, disingenuous. Disingenuous would be about the nicest term that I can come up with for that.
Oh, I could think of some other terms.
Right. Mr. Yannetti, a short rebuttal, I guess, or a short...
I guess, or,
comment.
you know, I guess, you know, if you want to.
I would just add, Your Honor, that the focus of Mr. Lally's argument was on everything except for Mr. Morrissey's conduct. Just like it doesn't matter if Mr. Morrissey and his office are actually targets of an investigation, it's only what he knew and believed. Similarly, with regard to his conduct in keeping secret the existence of a federal investigation, it doesn't matter whether we knew about it or not. It's the fact that Morrissey knew, kept it secret for 7 months, and didn't reveal it to the defense until the media got access to those letters. And with that, I would rest.
Okay. Thank you. So I do have a question. Did you file the Rule 17 motions already, or do you expect to file them later today?
We will be filing them by the close of business today.
Okay, and they're pretty much outlined in your previous motion, what you needed to file, or are there additional ones? in your
I
motion
believe
with the
they're
continuance?
outlined. Yeah, they're outlined, Judge.
Okay, I asked because Mr. Roach told me that on the March 20th date, the council wants it to be via Zoom. I'd prefer it not be, because with Rule 17, as you know, the record holders come into court and object. So I don't want you all to be on the screen. And Mr. Yannetti, certainly your local counsel. Mr. Jackson, if you want to be on the screen, you can. But I need somebody here,
I understood you, Ron. That's fine.
okay?
That's fine.
It makes sense to me.
Yeah. If I may just,
Yes.
can I appear in person and have my client join?
No,
us?
she has to be here.
Okay, thank you, Judge.
All right. Was there something else? Yes.
I would ask, may we approach just as the scheduling issues?
Okay.
Okay.
All right. You had a question, Mr. Jackson?
I did, Your Honor, just about the logistics of the trial, meaning days in trial, half days, 5 days a week, 4 days a week. I wanted to get some sort of sense so we can begin planning.
Okay.
what
So
the-
we're going to go full days, Monday, Wednesday, Friday, half days, Tuesday, Thursday,
Are the half days afternoon or half days morning?
mornings.
Okay.
Okay. Anything else right now?
Can I have 1 moment? No, Your Honor, thank you.
All right. Anything from the Commonwealth?
No, Your Honor.
Mr. McDermott?
Judge, I just wanted to put on the record that I think I provided to everyone copies of that letter from Google. I just wanted to make sure, just put that on the record that I gave you a copy.
Okay.
Thank you.
Who's Mr. Roach? Is that Jim, the clerk? Is his name Roach? Jim Roach? A lot of bombs were dropped today. A lot of bombs. Yeah, this trial should make national news. When is that trial on for? I thought I had it in my calendar. I know it's an April date. Anybody put that in the chat for me? I've been following so many cases that I am like confused. Okay, so she's taking this under advisement. She's going to issue a written decision. See how long that takes her. They're going to come back on March 20th for the Rule 17 motions, which, as you may recall from watching me before, a Rule 17 motion is regarding third-party discovery. I don't know what they're going to ask for now. That is similar to the motions where they were asking for Jen McCabe's Google search records, Jen McCabe's phone records, the phone records of Proctor, etc. That is what a Rule 17 motion is. So they're going to come back and talk about that March 20th. So we'll be back. Yeah, I thought it was April 16th. Right. Yeah. Thank you, Care Bear. Thanks, Care Bear. And you guys are amazing. April 16th is the trial is going to start. But oddly enough, those of us who watch trials all the time know that usually trials are 5 days a week, full days. Not here. Monday, Wednesday, Friday, full days. Tuesday, Thursday, half day mornings. I don't know why, but drag it out. So there was a lot. I'm going to recap it for you in a minute. Mark says, does Brady apply to grand jury, Melanie? They are supposed to present exculpatory evidence. That's what Brady material is, exculpatory evidence to the grand jury if they have it. That's one of the arguments here, that they had this information on Jen McCabe's Google search and they did not show it to the state grand jury, and therefore the indictment should be dismissed. That is a high bar, and my feeling is she's not going to dismiss the indictment on that, but we've heard a lot of evidence of why she should. I may be changing my opinion. So let's go over the evidence in a second after we go over the questions. Lisa, thank you so much for your super chat, just for being me. I appreciate that so much. Peter Estrada says, hey, Melanie, how long until they ask you to tone it down, or have they approached you already? Nudge, nudge, wink, wink. Listen, I'm in New York. I'm here to give my opinions. Okay. I am not a cupcake. I don't know where my little cupcake is not here right now. My goodness, what happened? It's been off the whole stream. I'm not a cupcake, wherever it is, over here. Can't make everyone happy. I'm not a cupcake. I'm going to share my opinions with you. I'm a legal analyst. That's what I do. I don't have to be impartial. I'm not a judge. Judges are impartial. Legal analysts don't have to be. I'm not a judge. I'm going to share my opinions with you. So no, nobody's reached out to me to tell me to shut up. I don't know if they will. I'm in New York. I'm not in Massachusetts. I have nothing to do with this case. I have no dog in this fight. I don't know anybody. I'm just talking about what I think is an injustice here. Because as we've learned, an independent FBI hired accident reconstruction expert with 3 PhDs has determined that a car did not hit John O'Keefe and John O'Keefe was not hit by a car. And those injuries did not come from a car accident. And I've been screaming into a closet about that for as many months as I've been covering this on YouTube. But even before that, when I was following the case and not covering it on YouTube. Jessica, congratulations for becoming a member. You're going to like it here. Agent 99. These lawyers, wow, defense have been amazing. How many trials we watched? Judge Rod Gutierrez, Reed's trial. Nothing like them. Nope. Becca, justice for Officer John O'Keefe. Of course, always 100% about the victims here and their family. So to John O'Keefe's family, our prayers go out to you, and we hope that justice is reached for John O'Keefe's death. We hope. We genuinely hope that. What is general admission? Oh, Nikki, that is levels of membership. It's just levels of membership here. People call their levels different things. And because I'm a avid concert goer, I named my levels of membership after concert tickets. So I think I have general admission, floor seats, VIP, backstage, something like that. I can't remember all the levels right now, but that's just something that I did on my membership. Care Bear says, Melanie, what do you think Bev is going to do? Well, I think we've seen that she's very conservative. She keeps talking about how high the bar is. Now this is going to be a very hard thing for them to prove. So it's going to depend on whether or not she believes all this stuff. So what did we learn today? We learned, Blessed in Texas, thanks for being a member, is the prosecutor sitting to his left? To whose left? I don't know. That is the prosecutor, Lally, the guy who is speaking. Question, you think the FBI gave defense permission to make these bombshells public today? They were entitled to talk about what they needed to talk about during the motion. Stacy, isn't it interesting how all these dirty DAs are being investigated right now all over the U.S.? I can't believe destroying evidence like this, especially against a police officer's death. Brenda Henderson, I wonder who tipped Jen off not to show up at court today. Maybe the same people she had a conference call with prior to her federal grand jury testimony. PTSD healer, thank you so much for your super chat, $10. I noticed he does not say the defense leaked grand jury testimony. Lunch at 4 p.m. is a crime. Yeah. Magnolia Gypsy, thanks for your super chat. Can the feds put Karen in protective custody to protect her from corrupt Commonwealth and this judge from going to trial? I don't know if they would put her in protective custody. I think there would have to be a showing of that she was in some serious danger, and I don't know if that reaches the level here. Melissa Smith, thanks for your super chat. Will they file a motion in limine for all the Turtle Boy stuff? Isn't it more prejudicial than evidential? I'm sure that is going to be one of the subjects of the motion in limine. And for those of you who don't know and are not Melissa, who seems to know what a motion in limine is, motion in limine is made before trial in order to either exclude or include certain evidence that you want a ruling on before the trial starts. So excellent question. And I do think that, yeah, I don't think a lot of the Turtle Boy stuff should be mentioned during the trial. I don't think it's more prejudicial than probative, which is the standard. And yes, you are correct. Wicked Psych, thanks for your super chat. Who was the guy sitting in front of the judge facing the court? Why was he submitting paperwork from Google to both sides? He is the clerk, Jim. Jim, the clerk. So I was like, Jim, what's the date? Jim, what's the date? Do we have the date? I was going to play part of this Outlier podcast for you and some of the things that that FBI agent said that was on Court TV with me, but I'm not going to have a chance to do that. So it is getting late here in New York, and thank you all for sticking with me until after midnight here on the East Coast. But I do suggest you go watch Brian's stream on it that he did last night, and she says a lot of things in that podcast, and I'll give you the specific timestamps that you can either go listen to her podcast on Apple or you can listen to Brian talk about it, except for now I lost my little pad where I had it written down. So here's what we learned today. The Google searches. The Google search that Jen McCabe made at 2:27 a.m. did in fact happen. It did in fact happen, and that was confirmed by a Quantico trained FBI agent who went over the data, and he confirms that that 2:27 a.m. how to die in cold search actually did happen. And then the two searches at, I think, 6:24 and 6:27 also happened as well. We also learned that Sergeant Lank and Trooper Proctor's close ties to the families involved here were not disclosed to the grand jury. We know that Proctor told Yuri Buchanan about his close ties to Chris Albert prior to interviewing, to the both of them interviewing Chris Albert. Chris Albert, right? Yeah. We know that Julie Albert, Chris's wife, texted Michael Proctor's sister to tell Michael Proctor that after all of this was over, she was going to get him a thank you gift. And then in response, Michael Proctor said, tell her to get my wife a gift instead. We know that Trooper Michael Proctor, who is the lead investigator in this case, was going to have, about 2 weeks before this incident happened, was going to have Julie Albert babysit for his toddler. We know that an accident reconstruction expert was hired by the feds, an independent accident reconstructionist with 3 PhDs, who said John's injuries were not caused by a car, and a car did not hit John, and John was not hit by a car. This was an independent federal hire, somebody who has nothing to do with this case. We learned a lot about integrity and about what Mr. Yannetti thinks Michael Morrissey does not have in that area. And in fact, one law professor used Michael Morrissey's speech as an example to his law students how to not be a prosecutor. We learned that there was a conference call between a number of witnesses who testified in front of the federal grand jury, including Nicole Albert, Jen McCabe, Matt McCabe, Brian Albert, Lally, and a victim's advocate. A conference call took place prior to them testifying in front of the federal grand jury. We learned that the DA's office gave permission to Brian Higgins and Brian Albert to either dispose of or go ahead and get rid of your phones, destroy them. We know that 5 minutes before the 2:27 how long to die in cold search that Jen McCabe's phone made, maybe she didn't make it, her phone made it. At 2:22 a.m., there was a call between Brian Higgins and Brian Albert when they both testified that they were asleep. And if that's not enough, we heard Lally say, the phone doesn't lie. The truth is in the phone. If that's not enough for you guys, I don't know what will be. I just can't. You can't make this up. You just can't make it up. And thank you, Galen, for your Venmo. And to Lori, who said go Buffs. Thank you, go Buffs. Thank you for your Venmo. And then I saw there was a Cash App. Galen for the Venmo. Thank you so much. And then I think I did the Cash Apps earlier. And I just want to thank all you guys for your support, financially, emotionally, and otherwise, and your search for the truth. And that's what we're here for. We're here for the truth. We just want to know the truth. And I think the truth is becoming more and more evident every day. And I don't know what killed John O'Keefe or who killed John O'Keefe, but the more and more and more that I learn, the more I'm convinced that it wasn't Karen Reed. So that's my story. I'm sticking to it. And I just don't understand why this case is still going on. Truth and justice, Janai. Truth and justice. Thank you, Maureen. I'm sorry that I kept you guys here so late. And to my moderators who are so amazing, best moderators on YouTube. Thank you, thank you, thank you for everything that you do for me. Could not have this channel without you. You guys are amazing. And to my channel members, thank you so much for wanting to be a member and for hanging around with me. My viewers, my replay viewers, you are all so, so, so important to me. I love each and every one of you very much. Feel free to come for me in the comments with respectful debate. I'm happy to listen to the other side. I really am. Like, if you think that none of this stuff has anything to do with whether or not Karen Reed hit and killed John O'Keefe with her car, please let me know. Come for me in the comments. I have merch that says it. Just be respectful, and I'm happy to debate with you. I don't know why there's so much vitriol in this case. I'm just Calling it like I see it. Karen is out on bail, yeah. And they have about $80,000 of her money that they've made arguments to try and get her money back because she needs it. This is a very expensive defense. Some money has been raised, I think, through a GoFundMe or something. And people are trying to help, but it's so expensive. It's so expensive. The truth is a virus. Thank you, Mac Nichols, says Happy Harry. Thank you guys for hanging in there so late. And remember, always be cool, be kind, be classy. It's not hard. It's really so not hard. Let's try and do that. Okay. This is a really vitriolic case, but hopefully the truth will prevail. Thanks, everyone. Have a great night. Hit the like button, the subscribe, the bell, all that good stuff. And that would be super amazing. Thank you so much. Oh, and Lizzie, thanks for getting in there with the super sticker. Appreciate you. Good night, everyone.